We all know about normal property ownership, where you are the owner of your entire property, which includes the yard and the house and all the fixtures and fittings, and you are more than you are entitled to do whatever you want with your property in a normal standalone house. But sectional titles are a little bit different, and I'm sure most of us will know that with a sectional title, it only allows an owner of property to own a certain part of an entire property. So if we think about, for example, an apartment building, so in that there's one building and all of these separate units or sections are so close to each other, but you as an owner of one of those sections only own your little part. You don't own the entire building. So it is a little bit different than normal ownership, the normal conventional ownership. And there's been a big move in the past few years or decades even in respect of people moving more towards sectional title schemes. And some of these reasons are because of the reduced maintenance duties. So you only have to worry about your section, increase safety and security, because most sectional title schemes will include extra and added security measures. And there's also sometimes shared amenities like communal clubhouses or playgrounds for the children, gyms, and even swimming pools. But with staying in a complex or a sectional title scheme, it does come with certain limitations. And this is what we're going to try and highlight today, is to just bring some awareness about what are these limitations and what are your rights as an owner. And it's important to know this before even considering going into into a sectional title scheme, because it might help to resolve disputes. Like the title says, knowledge is the key to dispute resolution. If you just know from the get-go what is expected of you and what you are allowed to do and what are your rights in general, it might help to just reduce some of these disputes that might occur under normal circumstances in a sectional title scheme. So when we look at what we are going to cover briefly today, is we're going to look at the main pieces of legislation governing sectional title schemes, just as an overview, the parties involved in sectional title schemes. We're going to distinguish between an owner's section and common property, as well as look at who is responsible for what. We're going to look briefly at the body corporate rules, annual general meetings, and levies. And then we're going to look at where you can resolve a dispute. For example, in this instance, we're going to look into a little bit more detail in respect of the Community Schemes Ombuds Service, or CSOS. So unfortunately, we only have an hour with you, and this is quite a lot, and it's quite a technical area of law as well. So we would really like to do as much as possible with you today. If you have any questions, pop it in the chat box and we will try and answer as much as possible at the end. If you want us to maybe focus on something in the future, a bit more in more detail, then when you complete the survey at the end, please remember just to make that comment and then we will take note of it. So when we look at the different pieces of legislation that govern sectional title schemes, we have three pieces of legislation. We've got the Sectional Titles Act, the Sectional Title Schemes Management Act, as well as the Community Schemes Ombuds Service Act. So the importance of just knowing this, it's just having that basis. If you are faced with a scenario or you need more clarity, these are preferably the three pieces of legislation where you will go and look at for further answers. It covers quite a lot of aspects, and all sectional title schemes are bound by these pieces of legislation together with their regulations. So when we look at the Sectional Titles Act, the Sectional Titles Act basically more deals with the establishment of a sectional title scheme. So it's more applicable to, for example, a developer who starts off a sectional title scheme. So dealing with the planning and the administration, as well as, and the registration of a sectional title schemes. When we look then at the Sectional Title Schemes Management Act, that is the piece of legislation that governs, and it's there in the name, it governs the management of the sectional title schemes. So this piece of legislation will give more guidelines and guidance on obligations and rights of all the relevant parties, whether you're the owner or the body trustee, for example, as well as how disputes must be dealt with. And that brings us to the last piece of legislation, is the Community Schemes Ombud, which establish the Community Schemes Ombuds Service as a platform for dispute resolution. So these are just the 3 pieces of legislation, and we also use these 3 pieces of legislation to combine and compile the webinar we're giving today. So I'm going to hand over to Lubo, who is going to give us a little bit more details on who are the parties involved.
Okay, thanks, George. So there are several parties that form part of a sectional title scheme. The first party is the developer. Now, the developer is the person who is the registered owner of the land on which the sectional title scheme is to be erected. Now, the developer will cease to be a member of the body corporate when he ceases to have a share in the common property. Now, the developer will cease to have a share in the common property when he has sold all the units. So when he has sold all the properties in the sectional title scheme. Then there are the owners. Now, an owner is the person in whose name the section is registered in at the deeds registry. Once ownership is attained, the person will automatically form part of the body corporate. Now, membership of the body corporate will cease when the person ceases to be an owner of a section in the sectional title scheme. So once the owner sells his section or his or her section, he or she will no longer form part of the body corporate. Now we deal with the body corporate. So the body corporate exists from the date in which any other person other than the developer becomes an owner of a section in the sectional title scheme. The body corporate in essence consists of all the owners in the sectional title scheme. So an important fact is that the body corp is perpetual succession and is capable of being sued and capable of suing in its corporate name. For example, where there is a breach of contract or damage to the common property. So now there are the trustees. The functions and powers of the body corporate are performed and exercised by the trustees of the body corporate. These trustees are elected at the annual general meeting. The functions and powers of the trustees must be performed and exercised in line with legislation, the sectional title schemes rules, and any restriction imposed or direction given at the annual general meeting. The trustees of the body corp stand in a fiduciary relationship to the body corp, so they must always act in good faith. The minimum number of trustees will be determined as per the sectional title management rules. Now, the last parties are third parties. These include service providers that are appointed by the body corp to provide specific service to the sectional title scheme. For example, security companies, accountants, administrators, estate managers, and so forth. The performance of these service providers is monitored by the trustees, and a report on their performance is given by the trustees at the annual general meeting. So I'll hand over to George to continue with the presentation.
So if we look at a case study, and Joe, like this one, for example, Joe and Carla are looking to expand their family and purchase a new home. They are worried about the security risks associated with living in a standalone house and are considering to purchase a unit in a sectional title scheme. So what they were thinking about as well is that if they buy into a sectional title scheme, they want some clarity on some legalities involved. So they've heard all these terms going about when they speak with other people about this, but they're not 100% sure exactly what does that mean. So what they want clarity a little bit on: what is a section, what is common property, who is responsible for what, and who is responsible to ensure the buildings or the units in a sectional title scheme. So I'm going to hand over to Lubo just to start us up and take us between what is the difference between a section and common property.
Okay, thanks, George. So a section is defined in terms of the Sectional Title Management Act as a section as shown as such on an approved sectional plan. Now, the section commonly extends from the center line of the walls, floors, and the ceilings. Sometimes this is referred to as the medium line. Simply put, the section is the area inside of the property in which the owner lives. So if we can use an example of a box, anything inside the box is the ownership of the owner, and the owner is responsible for. Anything outside the boundaries of that box, that falls within the common property. So the portion inside the box must be noted that this is the sole responsibility of the owner, and this must be managed solely by the owner. Now we have the common property. Now, the common property includes all parts of the building or buildings that are not included in a section. These parts include, but are not limited to, elevators, buildings, on the building's roof, common garden, parking lots, driveways, security systems, street lights, communal passages, staircases, and even the communal swimming pool. These areas are not owned by any of the owners of the sections and are the sole responsibility of the body corp. However, within a common property, there are exclusive use areas. Now, these exclusive use areas form part of the common property, but are reserved for the exclusive use of a particular owner of a specific unit. For example, gardens, patios, and parking bays. So I'll hand over to George to advise us as to the responsibilities of each party.
Before you buy into a sectional title scheme and you buy a section or the unit in one of these schemes, make sure that you do understand exactly what areas are your specific section, what forms part of the common property, as well as which areas do you have exclusive use to, because just from the get-go, starting off with that might solve quite a lot of problems. So you don't have any issues with, you're on my parking spot, but that's not actually your parking spot. And a lot of confusion could have been avoided just if you were clear from the beginning that, oh, that's not my parking spot, number 2 is my parking spot. Just a basic example. So when we look at who is responsible for what, so when we start with the owners, and as Lubo said, if we think about the analogy of a box, the owners are responsible for the maintenance of their specific section, so the inside of the box. It cannot always, and that means also that you cannot always just do what you want with the exterior then, because the exterior then forms part of the outside of the box, and that's where the body corporate will come into play as well. So if you stay, for example, in a townhouse complex that's a sectional title scheme, and you want to paint your section bright pink on the outside, that might not be allowed in terms of the body corporate rules, for example. They might want unity or a certain section of colors that you are allowed to paint the outside. And in some instances, you also need the consent of the body corporate before you can make any changes to the outside of your section. The responsibility may also extend to beyond the owner's section. Another aspect is that you must also, as an owner, allow access to the body corporate to maintain the communal system. So what communal systems refer to is examples like plumbing and wire. So this is, for example, where plumbing goes through your unit into your neighbor's unit, for example. And if something is happening and it's blocking it in your unit, it's not affecting your plumbing necessarily, but it affects your neighbor's unit. You cannot just refuse to say that nobody's allowed in my unit to come and fix this. You have to allow reasonable access to maintain this communal systems. And the big one as well, owners are responsible to pay the levies towards the body corporate and in order to maintain the sectional title scheme. So when we look at the body corporate, they are responsible for the maintenance of the sectional title scheme as a whole in general, and mostly the common property. So that forms outside of what the owner is responsible for. And they're also responsible then, as I mentioned earlier on, for the maintenance of the communal system, such as the plumbing and wiring that shares between some of these sections. But the big thing about the body corporate as well is they are responsible for the administrative duties in essence. The day-to-day management of what the body corporate should do is usually done by the trustees, as we mentioned earlier on. So the trustees will be nominated and voted for at the annual general meeting, and they will be mostly trusted with the day-to-day management of the sectional title schemes. And their biggest function is to act on behalf of the body corporate, all of these owners, to the best interest of the sectional title scheme. And some of their functions may be outsourced. So for example, a managing agent who will then take over some of the management functions if the trustees are unable to do that due to their commitments as well. Other service providers that can also be appointed is, for example, security services, accountants, and so on. So when we look at just this service providers, and I'll explain now why we mentioned them here. So these service providers are, as I said, security services, or accountants or gardening services, and they are appointed by body corporate or the trustees, and they have a contractual relationship with the body corporate. And not with the specific owners in general. So as a body corporate, as a corporate entity at the end of the day. So if an owner has a dispute with one of these service providers, they must report it to the body corporate or trustees, and try and establish what was expected of them, and the body corporate will take it on with the service providers to take it forward and trying to resolve this dispute. So, Luba, I think one of the questions that we saw in the case study was also about insurance.
So the body corporate must insure the building against fire or any other risk that may be identified. Now, the body corporate may pass a special resolution to include any other risk that may be identified from time to time. Now, should the body corp receive an insurance payout? Now, any insurance payout received by the body corp in respect of damage to the building must be used specifically for rebuilding and reinstating the building or the buildings insofar as they have been affected. In addition, however, to the insurance that is required by the body corporate, an owner may obtain an insurance policy in respect of any other damage to his or her section arising from a risk not covered from the insurance policy obtained by the body corporate. Now, an owner also has the right to insure against any risks, against a risk which is not perhaps due to his or her section. For example, damage to the unit below. Because as you explained before, George, sometimes it may happen that damage in an owner's unit may result in damage to the unit below or adjacent to the owner's unit. So I hope that clarifies the insurance part. So I'll hand over back to you, George, to give us our next poem.
Thanks, Luba. I think it does. I think this is something that not everybody's always familiar with, in the fact of, who is responsible to get insurance. You would always sometimes assume that it's only you as an owner who must get insurance for the entire section, but you're not maybe aware of the insurance that's been taken by the body corporate, for example. It's also important, just while we're on the topic of insurance, that when you use your property or your section, that you do not do something that will go against and increase the risk with the insurance that's taken by the body corporate. So it's always good just to try and familiarize yourself with that insurance as well, to try and avoid any possible increase of risk and possibly personal liability. And we can look at this case study, and where Peter, for example, has been staying in a sectional title scheme for a few years now, and he's frustrated by some of the rules of the scheme. He's just not agreeing with these rules, and he is planning to raise the frustrations at the next annual general meeting, but he is even thinking of not paying his levies in protest. And that sometimes I've heard about that as well, where people are saying, listen, the body corporate is not getting back to me. The body corporate is not doing what they're supposed to do. So why must I pay my levies? So just stop paying levies, and then they will probably do what they're supposed to do. So he just wants, what Peter in this scenario wanted to a bit clarity on was the body corporate rules, annual general meetings, and the levies. So Luba will kick us off with the body corporate rules and just give us a little bit of background in that aspect.
Okay, thanks, George. So body corporate rules must be formed and take effect from the date of establishment of the body corp. These rules must provide for the regulation, the management, administration, use, and enjoyment of the sections and the common property. For example, when certain events or noise is permitted. The rules must be, however, reasonable and apply equally to all owners of the section. This obviously limits the ability to do as you please. For example, if the rules do not allow for pets, an owner may not have a pet. Now, any substitution, addition, amendment, or repeal of the rules may be made later on at the next annual general meeting. The rules or any amendment or addition of the rules must be approved by the Community Schemes Ombuds Service. And once they receive an application or they receive the rules from a said body corporate, they will issue a certificate to certifying that the rules that they comply with the rules and that they certify the rules. Now, here's the situation. Sometimes the rules are not complied with. And as we all know, some of the people within a body corporate do not always follow the rules. In such a situation, a fine may be imposed on the infringer. However, a breakdown of the categories of fines associated with specific violations should be detailed within the body corporate rules.
Thank you, Luba. So it's good to see, just established to know it does limit you. It does limit what you're allowed to do and what you can do with your section. As I even said, it even limits a little bit with what you can do with the exterior of your section. So if you want to paint it the color, you need consent. If you want pets, you need consent for that. Or if, maybe pets are not even allowed at all. So that's also something you need to take into, because, I've heard in the past with people buying a sectional title unit, and then they do love their pets and they want to move their pets with them, and they buy this sectional title unit, and then only after they seal the deal, then they realize that, oh, no pets allowed. And then they sit with that struggle of trying to get the body corporate to allow them to have their pets. So it's also good to, just keep track of what you're allowed to do before entering or buying a sectional title scheme unit. Okay, so when we look at the annual general meetings, so the annual general meetings are usually there to discuss the affairs of and issues relating to the scheme for the past year and the near future as well. So this is where issues about, any disputes that might come across, or if you want to raise any issues specifically in the meeting, you are allowed to do that as an owner. The meeting must be held at least once a year within 4 months of the end of each financial year. And with that, notice must be given of this general meeting 14 days before the meeting. So they cannot just give you short notice, and this piece of this notice is given in order to make sure that everybody attends it. So you as an owner must be there in order for you to make sure that your voice is heard, and by giving sufficient notice will provide that period of time for you to prepare and make the necessary arrangements to attend. So while we're speaking about the owners attending, an annual general meeting cannot continue unless a quorum is present. So that means 1/3 of the owners must be present in order for this meeting to go on. If there's no quorum, the meeting cannot go on, and they must postpone it for another week in order for an extra notice to be given and to see if they can't get everybody there to establish a quorum. And then what you can do as an owner, if you are not allowed or not able to be there, you can represent someone else to act on your behalf as a proxy. Then what must be noted here is that the proxy cannot act for more than 2 owners. And then when we talk about the annual general meeting, decisions are made through the vote. So each owner has 1 vote, and this is how they make the decisions and see what will happen with any type of matter that must be dealt with by the body corporate. So it's important as an owner to be there in order to make your voice heard. If you are not there and there was a quorum and a decision was made, it is a bit difficult, to try and raise your dispute afterwards. So try and establish, if you get this notice, try and make the necessary arrangements to attend this meeting. So now we're looking at the body corporate levies. Lugo, if you can take us through that, please.
So in addition to maintaining his or her unit, an owner must also pay monthly body corp levies. These levies are provided to the owner via monthly statements and will generally provide the amount and the date in which payment is to be made. Now, body corporate levies, as explained before, are used by the body corporate to maintain the common property. The body corp also may further from time to time impose a special levy upon the owners of the section. For example, a special levy may be requested when there are special products that affect the whole building or all the buildings. These special levies are imposed after they are first projected and voted for at the previous general meeting. If levies are not paid by owner on a specific date, interest may be charged by the body corporate. In the event that an owner does not pay levies and legal action has to be instituted against the owner by the body corporate, the owner will be liable for all legal costs, expenses, charges, which are incurred by the body corp in recovery of the area levies. Now, in the case of body corporate of Fish Eagle versus Group 12 investment, the court stated that an owner of a unit is not entitled in law to refuse an increase in levies, nor are they entitled to refuse to make payments towards a special levy which has been imposed by the body corp. It was further stated that no owner is entitled to dispute liability for payment of levies on the ground that he or she thinks that the levies are excessive. Hence, it's very important for all owners to attend the annual general meetings, because the issues of the body corporate levies and an increase of body corporate levies are discussed and voted for in the annual general meeting. So it's important for all owners to make sure that at their best efforts to attend all the annual general meetings, as this can actually affect them financially.
Another thing to also take note of is the fact that, with this levies, you cannot just refuse to pay it. You have to pay it and until the matter is resolved. So just by refusing to pay it in protest will not necessarily solve the matter. And we're going into, if that is the case and the body corporate does not resolve the dispute and you feel that you are, your levies are not being used properly, for example, you can take it further for adjudication. So when we look at how we can resolve any disputes, so before we go on, we have to remember that whatever you do, when there's a dispute, either between you as an owner with the body corporate or you as an owner with your neighbor, for example, you have to try and resolve that matter in-house, try and resolve the matter as amicably as possible between yourself and that other party. This will include, for example, try and send them a letter, tell them, listen, this is the situation, or contact them, this is the situation, how are we going to resolve this? But if that has not come to any fruition, there's no resolution at all, you can refer your dispute to the Community Schemes Ombuds Service. And when we look at, as I said now as well, you as the owner can refer this, but also as a resident. So if you are leasing, for example, or you're a tenant and not the owner, you can also still lodge a complaint with the Community Schemes Ombuds Service. And when we're going to look at it in a little bit what types of matters you can refer, but when you look at when you look at this dispute, also think about who is this dispute against. Is it against the body corporate or is it against another owner or occupier? Then the steps that you have to take, as I said, you have to try and resolve it in-house between yourself and the other party as much as possible. And you have to inform them that if you are not going to resolve this matter, I am going to refer this to the Community Schemes Ombuds Service. Then what you also should take note of is keep copies of all communications between yourself and the other party, because that must be submitted with your complaint to the Community Schemes Ombuds Service, and they will then consider all of these aspects before making a decision on your matter. So just when we look at a certain aspect, so the Community Schemes Ombuds Service, or CSOS as well, I've put on here on the slide now the contact details, so you can write that down in the meantime, and just so that you have these contact details, go into the website, get clarity on a bit more information and clarity on what they cover and any other aspects that might be applicable. You can also refer any types of nuisance. So that's, for example, if your neighbor is playing loud music, or if there's any nuisance in respect of pets, you can try and resolve that. If it's not resolved, you can refer that to the Community Scheme Ombuds Service. Also, another thing is management of community schemes. So if you feel that the body corporate is not managing the community scheme properly, or as I said earlier on, maintaining certain aspects, certain areas in the common areas not properly, you can also refer that to the Community Schemes Ombuds Service. So when we're looking at fees, there might be a fee applicable when you refer a matter to the Community Scheme Ombuds Service. So just lodging a dispute would cost about 50 Rand. And then if the dispute goes for adjudication, it will be another 100 Rand fee. So how the Community Schemes Ombuds Service is funded is that the body corporate would also must basically charge an extra levy to the normal levies for the owners, because there's a certain amount of money depending on the scale of the levies payable that must be paid over to the Community Scheme Ombuds Service. So that's part of the funding. And then, as I said, there might be certain fees that you as a complainant to this Community Scheme Ombuds Service must pay as well. And then just looking at the procedure in brief as to how the Community Scheme Ombuds Service will try and resolve this matter. So first, they will try and resolve it through mediation. So that would be, they will communicate this dispute to the other party and get that other party's input as well, and see, isn't there any way that we can try and resolve this matter as soon as possible? If it's not resolved and the parties cannot agree on any way of the resolution, then it will go over for adjudication. And that is usually in the form of a formal hearing at the Community Schemes Ombuds, and where a chairperson will be present as well, listening to both of the sides and making a decision and giving an order or an end result at the end of the day and saying, this is how we are going to resolve the dispute. Another thing that you must take note of is the fact that there's no legal representation allowed at the Community Scheme Ombuds Service unless you applied for it and it has been approved. So if you feel that this is a complicated matter and you want a legal representative like an attorney there, you must apply to the Community Scheme Ombuds Service. They will also then, talk to the other side, the other party, and say, do they have any objection to you having a legal representative there? If everybody's fine with that, they will allow legal representative, but you have to apply for that. And then after decision has been made at the Community Schemes Ombuds Service, then you can appeal it to the High Court within 30 days if you are not happy with the decision that has been made. So this is just, the basic procedure of how to refer a dispute. Yes, Luvo.
Can I ask a question? So what happens when an owner can't afford the fees?
Okay, thanks. That's a valid question, Luvo. Thanks. So if an owner cannot afford these fees, there is an option to apply for a waiver to the Community Scheme Ombuds Service. So you can ask them to waive these fees for you. There's a certain scale that is also applicable. It's about 5,500 Rand for the gross income of a household. And that's where they look at, so if you earn below 5,500 Rand for the household, then you may apply for, a waiver of these fees. So there is a way. So if you think about it now and you think, oh, but now I don't want to refer this matter because I cannot afford it and nothing's going to happen, you can apply and ask them to not charge you these fees and they will make a decision on that. If anybody has questions, I see there are some questions. I'm going to stop sharing and then I can see the questions better myself as well. Luva, are there any questions there that you want to take on first?
Okay, let's start with the first one. I'll start with the one from Peggy. Peggy is asking, do nominated trustees get paid? So no, nominated trustees do not get paid. On top of that, it must be noted that obviously with the trustees, they stand in a fiduciary relationship towards the body corp. So they must not get any personal economic benefit, no matter if it's indirectly or directly. Now, if a body corporate, trustee breaches its fiduciary duty, it must also be noted that they can be held personally liable for that breach in terms of the Sectional Titles Management Act, specifically the sections that deal with it is Section 7 and Section 8.
Thanks, Luvo. And while we're still on the topic of trustees, I just want to add something in respect of, if you are a trustee, you've been nominated, you've accepted this nomination, and you are now in this position, and halfway through you realize that this is not for you. A trustee is allowed to resign as a trustee. They must give written notice to the body corporate as well, but they are allowed to do that. So it's quite important to, before you accept a nomination and you become a trustee, to understand, because as Lubo said, you have that fiduciary duty and you can in certain instances be held personally liable. So it's quite important to understand what's expected of you so that you don't have to halfway through your term decide, oh, I don't want to do this, and then go through a resignation. But it is a possibility to do that. Lubo, if you can maybe take the next question as well. So if the rules have not been submitted to CSOS, will it then be invalid, and penalties, and if there's any penalties made provision for in the rules, will those penalties also be invalid?
Okay, thanks, George. So before the rules are approved, well, if, for example, there's amendments to the rules or there are rules that are submitted to CSOS, there are always previous rules that are there that the Sectional Title Scheme has been using in effect. So those rules will stay in effect until the ones that have been approved by SOS. So there will always be some form of procedure or some way of actually dealing with any infringements of rules or the conduct of the owners within the body corp.
Another question that we have is in respect of the fees allowed once it is handed over and interest charged. Is it still the attorney and client and further maximum 24% per annum? So from what I understand with this is, and when you hand over something for, the normal attorney and the normal legal procedure and the the fees allowed there and the interest rates they will apply. But do you know perhaps if you can have a certain interest rate in the body corporate rules to say that, if you are late with your levies, these are the interest rates, or will the prescribed rate of interest apply?
So, George, with these cases, obviously the normal court rules will apply. So the same process as any other incidental credit that happens, the same as any other debt that is incidental, the normal rules will apply. Even when it comes to the court rules, the normal rules will apply.
Thanks, Luvo. Another question here: if one trustee insists on using the funds of the body corporate to repair a wall belonging to the community and not the body corporate, can you refer same to the CSOS? So if I understand this correctly, I'll give you now, Luva, it's thanks. If I understand this correctly, it's like the one trustee is not in the body corporate, so it's not property forming part of the sectional title scheme, but rather outside of the sectional title scheme. So in the community, there's a creche and you want to help the creche, for example. I hope I understand this correctly. I don't know if you understand it like this, Luva, as well.
Yeah, George, I do understand it like that. So what happens is that, obviously, as you know, the body corporate levies are used strictly for the common property. Now, as I stated before, the trustees have a fiduciary relationship towards the sectional title scheme. Now, if, for example, they cause the body corporate to suffer economical harm, for example, now you're going on and above your abilities, then obviously then that trustee in itself can be held personally liable for that cost, because the body corporate levies are only made for the maintenance. Hello, am I still there, George?
You're still there. Just repeat quickly. I don't know if you were lost for everybody. I just missed a little bit. Yeah.
Okay, no problem. Yeah, so I was saying, I'll start from the beginning. So
Thanks.
the body corporate levies are to be used for the maintenance of the common property. Now, obviously, now if the levies are used by that one trustee for other things, it means that now the trustees has caused economic harm to the body corp in itself. Now, because they've exceeded their fiduciary duty to the body corp. So now, in such a situation where that one trustee acts outside of the ability, then they would then now be held personally liable for that bridge.
Mm.
And yes, the thing is, also with claims to the CSOS, you can bring any claim to the CSOS. It does when you get to the CSOS, they will advise you whether or not, and they will adjudicate on your matter and advise whether or not the claim is successful. So anyone who's an owner in a community scheme may approach them and provide any dispute that they have in terms of the sectional title scheme.
And this forms part of one of those matters you can refer to the ombud, in the sense of it's dealing with the maintenance and the management of the body corporate scheme. So they are using the money to manage something else and not the body and not the units, or the common property. So this is definitely something you can refer. And then another question here: where or how do you challenge a fine for breaking one of the rules? Who decides whether you are guilty?
Yeah, so the body corporate rules clearly define which conduct is guilty of an offense. So once you are guilty of an offense, obviously they have to issue out a penalty in line with the rules. If, for example, you are now wanting to dispute that penalty, you can dispute it with the trustees and tell them that, look, you're disputing this particular rule, that you are not guilty. Then the trustees will have to obviously look at your dispute. If they find that you are guilty of the infringement in terms of the rules, then they will say no, they'll continue with the fine. Now, if you don't agree with those fines, then yes, you can take that to CSOS also, in terms of Section 38 of the CSOS Act. So you can then proceed to CSOS, and CSOS will go through the conciliation and arbitration process, as George explained in his last slide.